We are deeply honored to welcome Boaje to IBDT, who has been here for the entire week teaching our students and in very interesting topics, very challenging number of issues to be dealt with in just 3 days. And now we have the pleasure of bringing to Brazil to our students and to the audience his work results on artificial intelligence applied to international tax treaties, and especially to the principal purpose test, which is a quite difficult thing to handle. And I honestly would never think that artificial intelligence could go so far as dealing with something so vague and imprecise, abstract. But you will be amazed with the results. Please.
Thank you very much, Victor. It's a pleasure to me to have opportunity to share with you findings regarding the possibility. So it's about possibility, I need to emphasize it, to use AI technologies and its subdomains such as machine learning in order to address international tax avoidance. We will focus on tax avoidance under tax treaties today. Therefore, I will try to make a connection between AI and the principal purposes test, PPT. As we all know, PPT is going to be new global standard in respect of addressing treaty abuse. And if we read PPT together with the new preamble, we know that PPT should not be applied to situation of double non-taxation or reduced taxation if there is no tax avoidance, because preamble is clear. The purpose of tax treaties modeled on the OECD model is not only to eliminate double taxation, but to do so without creating possibilities for double non-taxation or reduced taxation, following from either tax avoidance or tax evasion. So my first assertion, you are welcome to disagree of course, is that there is no treaty abuse without tax avoidance. If in results of transaction or arrangement there is double non-taxation, but this is just the casual result of business which was conducted for many years, there is no tax avoidance element, and therefore PPT should not be applied to deny treaty benefits. But the wording of the PPT, the structure, the content is very vague, very ambiguous. Therefore, I suppose Victor said that he was a bit surprised that we can already today speak about possibility to use machine learning to address issues regarding application of the PPT. As a matter of fact, I was contracted by the Singapore Management University to conduct research in respect of Singapore mainly, but I convinced them to take broader view and on more global, look on the problem of taxation from the global perspective, therefore MLI. But in the end I thought maybe it would be fun to go a little bit outside the box of tax expert, maybe even more than a little bit, and conduct interdisciplinary research without any help from other discipline. I was just reading books about algorithms, AI, articles. I learned that there is a way too much hype in respect of AI than reality. And one good findings, I think, for all of us is that AI will not replace lawyers, at least not in the next 50 years. AI at best may augment, may support, may improve the efficiency of our work. And today's seminar will be also about that. It's not about replacing tax expert in respect of application, the PPT, but augmenting their work in that respect. So the purpose and the scope of today's seminar is to make an attempt to answer to these 4 fundamental questions. First, start with why. So why we do not have AI tax treaty assistant yet? You may ask me. We have big 4 companies using a lot of money, and not only money, but also a lot of top world experts, and also they use data scientists in respect of development several AI technologies. So why there is no AI treaty assistant yet? It will be first question that I will address. Second one, why AI is needed and why it is suitable for cases of treaty abuse under the PPT. Why not other rules? Why PPT should be priority right now? The third question, who will be helped and in what way by applying AI to the PPT? In other words, if we assume that AI technology in respect of the PPT may be commercially viable, who will be that want to buy that product? So we will speak here about potential users and benefits that can they can achieve via AI treaty assistant. And the last question, how does the AI tax treaty assistant work and what can it do? So it's about functionality. Before I will start to answer the first question, let's set the scene at the beginning. So this man maybe is not the most handsome man in the history, but he was one of the smartest and most important US president, Benjamin Franklin. He's also on $100, so it's worth to have a lot of faces on the banknotes with him. So he's famous, and I know that it's cliche that everybody knows it and everybody repeats it in many books on many occasions. He said that there are only two things that are certain in life: death and taxes. So well, I tend to agree with death. We still cannot become immortal, maybe in the future. Maybe first AI will replace lawyers and then we will become immortal. We don't know it yet. But we know that taxes are for sure not like death. They are avoidable. And I may not be authority to you, but tax advisors of multinationals such as Google, Caterpillar, Apple, Amazon, Starbucks should be authority to you. If you ask them, or if you just look on several articles and publications which revealed the tax avoidance schemes of these MNIs, you will figure out that just by 2015, only US multinationals managed to avoid taxes on income in amount of $700 billion US. So this number may not tell you much in isolation. So I will make a small comparison. United Nations had ambition plan in 2005 to reduce the poverty in the world by 50%. And this amount of money was enough, 15 times more enough to achieve that goal, just from tax avoidance at the level of US companies. So it's a big problem, especially in the context of economic crisis in 2008, 2009. Countries try their best to have more money. So we have famous BEPS project. We have its derivative in the form of anti-tax avoidance directive. And we have also many domestic movements against BEPS, against international tax avoidance. For example, anti-diversion taxation recently implemented by Australia, France, or United Kingdom. One of the main results of anti-international avoidance phenomenon are rules that are very general, very vague. For example, proposal of general anti-avoidance rule under the anti-tax avoidance directive, or famous or infamous principal purposes test, the PPT. In the face of these challenges, taxpayers will need to comply by running their international businesses and investments with very many new anti-tax avoidance rules. And the ones that are very general and ambiguous, like the PPT, are the most challenging for them. They are so ambiguous that it's almost impossible to predict their application upfront. It is also new standard, so we have no references to which we can use as a point of reference. So I was thinking, what if we could support our typical lawyers' legal thinking, legal reasoning of qualitative nature with more quantitative approach stemming from math, stemming from statistics, and eventually maybe combine this with machine learning and AI. So the purpose of my research in Singapore in the end was to examine the reasons, the possibilities, and the ways to develop and apply AI in international tax avoidance cases covered by the PPT. If this becomes successful, we can move to other types of anti-avoidance provisions. We could use the same approach to design algorithm to domestic GARs, to CFC rules even easier because CFC rules are more technical, to transfer pricing legislation, and so on and so forth. So again, you can ask me why you decided to do it with PPT. Because PPT will be applied globally, while domestic GARs differs among countries. But then we can also overcome it by looking for similarities. But let's start first why there is no AI in treaty domain. So when I was searching for historical reasons for the origin of AI and law, I was very surprised, positively surprised, that one of the first successful and internationally recognized projects regarding AI and law was precisely about tax law. It was then assistant professor at the University of Harvard, Professor McCarthy, who developed this AI system called Taxman. Taxman was capable of addressing various issues regarding reorganizations of US corporations. Taxman's purpose was to determine whether or not certain reorganization of US corporation is exempt from taxation in the US. So it was very narrow, only US tax law, only a fraction of US tax law. But it was already in 1972. So the idea and the effect of that idea was much older than me. Whereas I was thinking that AI and law is something very new. It's just emerging, maybe 2010 first idea, but it was already in 1972. So I thought maybe it was an accident that tax law so early became a topic for AI and law. And it was not an accident. In 1970s and 1980s, there were much more projects regarding AI and tax law. For example, tax advisor system developed by Professor Dean Schlombaum, tax return consultant, designed and implied by a team of artificial intelligence students at the University of Toronto, or tax advisor invented by Professor Robert Michelson. And interestingly, Toronto is now one of the capital of AI and tax law. Blue G Legal, together with Thomson Reuters, Blue G Legal is the name of the company established by one of the professors of law from University of Toronto, Ben Alaria. So Ben, together with Thomson Reuters support, a computer scientist, established successful startup, and one of the products is called Tax Foresight. Tax Foresight currently covers only Canadian tax law, but they want to go beyond. They also cover GAR, but without much successes so far. So then I was thinking, what is so exceptional about tax law in comparison to other branches of law that tax law was so susceptible to AI system, AI projects? So I thought that the citation of Professor McCarthy is worth to share it with you now. He said that simplest legal problems are the hardest for an AI program because they require human experience, which is alien to AI but inherent to lawyers. Being highly technical and complex, tax law is very difficult to comprehend and deal with by lawyers, but should not be so for a dedicated AI. So AI with injected knowledge of tax expert. And if we think about it a bit, it's kind of wise to say it, because criminal law or civil law are more related to ordinary life. They deal with concept of death, birth, marriage, custody over children. things that are inherently human, while tax law is subsidiary in nature and follows already established phenomena like purchase and sell agreement or organization of companies. Such events exist only by virtue of the human decision on paper normally, and tax law reflect them. So I was researching more and more, and I figured out that more research was done on AI and law, the more it was clear that it's impossible to replace any lawyer with AI. So you may say that the research about AI and law was fruitless, but no, because it discovered, it revealed what is the problem, what is the most challenging part of law and legal's work that cannot be yet addressed by AI. And first thing is that tasks easy for humans, for example, common sense reasoning, reading and understanding, happen to be most difficult for AI. Still, AI can win with Go game, Jeopardy, chess, poker with the best human player, but is not capable of reading simple emotions or understanding of the text in a human life situation. Moreover, as lawyers, you must know that knowing the law, understanding legal norms, is not only reading the law, but also seeing the law through the prism of its purpose and effect. And purpose and effect of the law is always related to the human's behavior, because law regulates human behavior. And again, human behavior is alien to AI, because AI is not human. And last but not least, our profession could be characterized by high complexity, uncertainty, and dynamic nature of the profession is also quite clear. Because law changes, and law sometimes changes very frequently. For sure, international tax law.
Is this the I would say the most famous work on the concept that humans will be replaced by robots, right? This is the work that sort of predicted that in 10 years, 20 years, always you see this on the papers, right? Like half of the jobs will be replaced by robots. And if I remember well, there's a list at the end of this study which lists all the occupations based on the US Social Security Code, so you can really check which occupations have the greater chance or not, and we lawyers happen to be in a very comfortable position so far, right?
Yes. That's correct, Victor. Thank you for intervention. But if you are a tax collector, you can be easily replaced very soon. So if you have kids or you plan to have kids, don't advise them to become tax collectors. They have more chances to be replaced with machines than parking slot attenders, for example. And also, this research was criticized because it took very narrow approach, and there is new research of MGI Institute and OECD, and the new researchers take broader approach. But for the purpose of my research, the outcome of the research of Frayne and Osborne and OECD and MGI are coherent, are convergent, so it's all good. So from comparison of theoretical and empirical research follows that AI, which could be capable of replacing lawyers, would be no longer AI, but AGI, the so-called artificial general intelligence, which means it will be technology capable of using intelligence like we in every possible situation, but with computational power millions times bigger than our, and the same with storage millions times bigger. Which means that such technology with access to internet will be in a few days or maybe in several hours no longer AGI, but ASI, artificial super intelligence, with capability of almost everything. For example, capability of manipulating the structure of atoms. So it can change you into Apple or Apple into you, which is almost insane. But experts of AI speak about that with high level of certainty. So why you should use something that is capable of everything to address PPT or tax law, right? There is a huge gap. We may use AI to support our work, but not to replace. It was a huge paradigm shift, among the others, from the paper of Richard Susskind in 1996, when the whole AI and law community concluded that yes, it's true, we should not continue our work to replace lawyers with AI. We should focus on the areas of law that are very susceptible to be improved by AI. And from then on, there was a small boost of successful, commercially speaking, AI law startups. One of them is Ross Intelligence. Ross Intelligence uses ABI Watson natural language processing, and by receiving comments in the natural language, for example, you can say, "Hi Ross, find me the Supreme Court in Norway regarding the application of Norwegian GAR in respect of tax treaties," and it will find you. So it's more like searching databases, and it focuses mainly on US bankruptcy law, intellectual property law, and labor law. Then we have Luminance, which is capable of overviewing thousands of documents at a glance and uses pattern recognition, statistics, and supervised and unsupervised machine learning. And we have also mentioned by me Blue G Legal from Canada with tax foresight, which works as a predictive engine and predicts the outcome of judgments of Canadian courts in respect of certain cases. Now, question to you. Are you familiar with, or maybe even better, are you using in your work as a lawyer one of these programs, these systems? No.
I don't know of the audience, but I had never heard of a Brazilian firm using any of these. Someone in it.
Syntax.
Right. Yeah, and we heard that the federal lawyers are using some sort of mechanism, right? I don't know if someone heard of that, but yeah, maybe it's just whispers. Anyway, it's not really developed in Brazil. Syntax.
Okay, thanks. So we have Syntax in Brazil, a new player. There will be big AI and law conference in London by the end of May, and among the others, the CEO and founder of Ross Intelligence and Luminance will be keynote speakers. So if you can attend that conference, I advise you. It's about the future of our profession. It would be nice also to meet people and discuss with them several topics. But there is no single startup, successful or not successful, which could address so complex and ambiguous rules like PPT. I spoke with Professor Ben Alaria, who is CEO and CEO founder of Blue G Legal, and also I spoke with his researchers, and they both told me that the rate of precision of tax foresight is the lowest in respect of GAR. It's so low that they decided to not use tax foresight in respect to Canadian GAR as a predictive tool, but just more like Ross as helping people to find relevant case law. And there are at least two reasons why machine learning is not suitable to ambiguous and general rules like Canadian GAR. Because Canadian case law is not consistent in application of patterns that follow from Canadian GAR. Sometimes judges follow some patterns that are clear, that are established, but then they deviate from them without any good reason. And second reason is that there are very few cases with GAR, as we know, even if we take into account the global case law in respect of GAR. While machine learning likes to be fit with a lot of data. So we have no big data in respect of GARs, and we have no consistent application of GARs by judges. So there are these two challenges. So I think we all are happy with the answer to the question why there is no AI yet in respect of the PPT from the technological and historical point of view. Last most obvious reason for that is that nobody will pay you for something that is not yet in force, and PPT is not yet in force. So the main difference between academics and practitioners that I found in my life is that practitioners worry about changes only if it's sure that something will apply in 2, 3, 6 months at maximum. Otherwise, their clients are not worried, and therefore they are not worried too. But we academics like to discuss something, analyze something already at the early stage, for example, at the stage of projects, at the stage of discussing changes even. So the last reason is that PPT is not enforced yet, therefore people don't put that much emphasis for that. But I spoke with people from EY in Singapore, and I know for them that the global leaders of AI in Japan, Switzerland, and UK, London, they are all engaged in creating AI technology in respect of the PPT, completely irrespectively, of course, of my idea. But it's interesting to see that they also see the potential to do it right now. So let's move to the question number 2. Why AI is needed and useful to applications of the PPT? So the issues of treaty abuse. First, massively important thing when we speak about machine learning and the commercial applications of machine learning, scalability. PPT is designed to address treaty abuse globally, not in one country, but globally. So we have one and the same language of PPT, English and French, which is supposed to be translated and implemented by all MLI countries, and not only, as we will see soon. So under MLI, only the PPT was self-standing option to meet the minimum standard under Action 6. LOB was not enough, super complicated, super technical, alien to many countries. So only 12 countries out of 78 currently decided to have LOB. But so few countries does not trigger many matches, while PPT will trigger 100% of matches, which amounts to approximately 2,000 tax treaties around the world. And it's not the end of the story. Because most recently, we witness that countries which are completely outside the MLI, such as Uzbekistan or Brazil, but Brazilian example is less obvious. Brazil could be, but decided to not be, while Uzbekistan was very far away from the G20 and what happened in BEPS. So we have countries outside MLI, and we have also treaties outside MLI, such as the UK-Swiss tax treaty, and yet protocols to UK, Uzbekistan, and UK, Swiss, and Brazil-Argentina tax treaties prove that PPT will be applied under those treaties, which means that the number 78 countries and 2,000 tax treaties is underrated. PPT will be applied by more than 78 countries and will be applied under more than 2,000 tax treaties. So with such high scalability, having highly effective and precise AI technology to support lawyers, support M&Is in their decision in respect of cross-border arrangement or transactions may be successful. And once PPT will be incorporated in tax treaties across the world, it is very unlikely that it will be eliminated or changed soon, because the critical mass is huge. It will be almost 100 countries. Once they decide to do it against the international tax avoidance, it's unlikely that it will be changed in 1 year, 2 years, or even more. While changes under domestic laws are more prone to take place. Also, under domestic law, it's enough to take decision by one legislative body. But in case of PPT, at least 2 legislative bodies need to take the decision. And that decision must be preceded by the negotiation procedure, negotiation of changes in tax treaties. So we have one global rule with the highly complex area of international taxation. So it's first reason why I decided to focus on PPT. And second reason is to make the unpredictable predictable. What is unpredictable? Of course, an application of the PPT. This is the wording. We have one sentence, 11 lines, very broad phrases alien to many jurisdictions apart from UK, because PPT was written by British lawyers. OECD took advantage of native speakers in their group. US said we are outside MLI, so they were left mainly with UK. But UK is not the only one country, the most important country. What is agreed that this is a very vague and very broad rule. It's so broad that it's hardly predictable by lawyers. So what if we have AI system which is based on internationally recognized rule of interpretation under Article 31, Paragraph 1 of the Vienna Convention? And what if that technology would be capable of recommending the result of application of the PPT? In other words, we can use this recommendation as a risk factor if we are MNIs or taxpayers, or as a detection of treaty abuse if we are working for the governments of MLI countries and other countries that decided to include PPT in their tax treaties, for example, Brazil or Uzbekistan or other countries outside MLI. And the last reason, I think most important for OECD, at least it should be most important reason for OECD, and most important from the perspective of treaties, is to ensure an appropriate application of tax treaties. Let's quote Philip Baker, who is the British expert in international tax law, one of the top experts in the world in international tax law. He represented, for example, the government of Mauritius in the Vodafone case, government of India in similar case. He represented Apple in the case against European Commission, and then he represented European Commission in the same case. So he is extremely good, not only as academic, but also as a practitioner. And he said that there is every reason to fear that once the MLI is in force and a large number of countries, including ones with tax authorities, they do not have a reputation from predictable interpretation of tax treaties, and I guess that perhaps in Brazil it may be the case. If such countries begin to apply the PPT, this will undermine the whole system of tax treaty benefits. And this is said by the top expert in the world in respect of tax treaties. So the lack of certainty and foreseeability under PPT is so big that it may endanger the whole functionality of tax treaties, because taxpayers will no longer be able to predict if they can receive treaty benefit or not. And again, if we have up our use one and the same algorithm based on the international rule of interpretation and others globally accepted sources of interpretation of the PPT, such as OECD commentary, Action BEPS 6, and the top experts' articles, scientific articles, then it may be useful to use such AI in our work regarding PPT. So this is my why for AI in PPT, at least at the beginning. Let's now move to question number 3. Who can benefit from the PPT? So I identify at least 3 groups. They may be more, they may be less. Of course, it depends if we focus more on the commercial side of that idea or more of the global side and try to include as much beneficiaries as possible. Obviously, number 1, taxpayers. It will be applied predominantly to multinational enterprises because they are casually involved in international arrangements and transactions, while the PPT target such arrangements under tax treaties. It may be used as assisting in compliance with the PPT in the 2 ways or more. It can assess tax consequences of cross-border arrangements or transactions upfront in a very precise way. So it will be like a risk indicator, whether we have very small risk to be targeted by PPT or high, and how to adjust this risk, how to reduce it if the risk will be too high. This will help tax payers, MNIs, at a very early stage either to redesign existing schemes or change their views in respect of schemes that are not yet implemented but were proposed to be implemented by either internal or external tax advisors. So this group, I think, is quite clear. It's not controversial. A little bit less clear is how tax authorities of contracting states may benefit from the AI technology. Here, AI technology may assist them in applying the PPT. First, they may use it to evaluate the taxpayer's arguments for obtaining treaty benefits. For example, it will be obvious that not only principal, but the sole or the essential purpose of the transaction or arrangement was to obtain treaty benefits, but taxpayer will deliver arguments according to which such obtainment of treaty benefit is in accordance with the purpose and object of the relevant treaty provision. And here AI may be used if this is really the case. It may also, by it I mean application the AI to PPT, it may also contribute to the higher consistency and predictability of tax authorities' application of tax treaties in light of the PPT. Because without that, the rule is so ambiguous and broad that tax authorities may change their views even several times the same month, but with having one and the same algorithm, this will be impossible unless they completely ignore the algorithm or they will be not interested in using that product for other reasons. The most controversial group of possible beneficiaries of AI technology are, of course, judges, because why judges should use it? So here I would say that they can use it as assisting tool for their supervision of application of the PPT. Just as tax authorities can use AI technology to evaluate taxpayers' argumentation, judges can use this technology to evaluate argumentations of both tax authorities and taxpayers. It may also increase the quality of tax treaties case law, more consistency and more predictability. I challenge myself in the paper by analyzing the AI predictive tools in respect of case law, especially case law of US Supreme Court. And as a matter of fact, algorithms to predict outcome of case law were designed without taking into account legal factors. They instead focused on purely non-legal factors like the origin of the education of the judge, whether he was liberal or conservative, whether he or she ate lunch before delivering decision. So for the purposes of PPT, they were completely irrelevant. But if they are successful without taking legal factors into account, they should be even more successful if they take legal factors into account. As a matter of fact, take only legal factors into account. I'm talking now about treaty abuse algorithm. Moreover, I was trying to find a legal argument for that, in a sense, how to allocate using AI technology under Vienna Convention rules. So I would say that using outcome of AI technology under PPT would belong to supplementary means of interpretation under Article 32 of Vienna Convention. The same as publications of famous professors. They are sometimes included and recognized by judges, especially publications of Klaus Vogel, while other scholars are ignored by them. I also figure out that they are converging benefits. So taxpayers, tax authorities, and judges, and even contracting states may benefit from AI technology being applicable to PPT, because the purpose of the algorithm of such technology will be to ensure appropriate application of tax treaties by ensuring appropriate application of the PPT. So we increase something that exists at a very low level, means predictability. We increase predictability and we make application of PPT consistent and precise, which in turn may contribute to the appropriate application of tax treaties. And the more accurate and predictable application of tax treaties by authorities, by tax authorities, of course, less disputes. And when we have less disputes, we have more space, more room for international commerce, for international transactions and arrangements. And this eventually may contribute to an overall amelioration of relations between contracting states. And now, last question, how does the AI tax treaty assistant can work? So question to you before, do we have any machine learning or AI experts in this room? At least somebody who read one article or book about AI or machine learning? Okay, so I feel a bit safer now. Because I am just a doctor of law, having not much to do with new technologies, but I learn by reading quite a lot in that respect. So let's see what I learned. I figure out that the best idea from the machine learning and AI approach to use technology to PPT is the so-called KBAI, knowledge-based AI. What does it mean, knowledge-based? Well, it means that this is not like deep neural network, that you don't need to put any label. You just show them game and tell them just play a million times every day and you will correct yourself. Knowledge-based, it means that you inject the expert knowledge at the beginning, and this is something that always takes place as an input. Why this idea? Well, first of all, normally the best inventions are reinventions. So Taxman in 1962 was based exactly on the KBAI approach, and it was first one of the most successful and internationally acclaimed AI system in respect of law, tax law. So why not to try use the same approach in 2018? Moreover, something was missing in 1970s and 1980s and even 1990s. Something was missing, something super important for successful AI and law. What was it? Question to you. Now we have an abundance of it, but in 1970s, 80s and 90s was no something else. This as well, Victor, good computers, but what do you think? Yes, access to data, especially access to semantic data. Now we have enormous, easy access to enormous amount of data. Kurzweil, famous futurist on AI, said that nowadays 7 years old African kid has access to more knowledge than 20 years ago US president. And it's kind of interesting statement. So now we have possibility of synergy with access to wide coverage semantic knowledge. And this makes this simple, good old AI, which is KBAI, way more powerful than years ago. This creates the so-called virtuous cycle for knowledge discovery and management. Professor Michael Bergman illustrated this in that way. So we have knowledge-based algorithm that I will present you in the end of my presentation. Nowadays, it was just applied a few times because I just moved from Singapore to Brazil and I will continue my journey to Europe soon. So I didn't have possibilities to use this algorithm many times. But if it will be used many times and eventually combined with machine learning, then it will become artificial intelligence with greater scope and fewer errors. And this will go back to this algorithm, which is based on the expert knowledge. And again, being applied more and more, there will be more discovery and better self-management of the product. Two ways of retrieving information. First way that you will participate in this way very soon is the so-called human input narrative. So we will have question answering engine, and by answering to the questions, we will provide the algorithm with data needed to determine the risk of denial treaty benefits. In other words, the risk of treaty abuse. This is the so-called supervised classifier system. Why supervised? Because it required some initial guideline. And this guideline follows from the expert knowledge manifested in the form of questions. But the second step, more sophisticated, is automatic narrative. So here there is unsupervised natural language recognition or semi-supervised natural language recognition system In other words, at this second stage of machine learning, AI technology will be able to read documents, for example, agreements between companies, financial statements of the companies involved in transaction or arrangement, in order to conclude whether or not there is a risk of treaty abuse just based on the automatic reading of such documents. But this is the second stage. And the first and the second stage are related to each other in the sense that this virtuous cycle also applies here. So once we will achieve maturity at the stage number 1, we can move to stage number 2, and they will simply coexist. This is the so-called combination of wholly and partly supervised pattern recognition and learning classifier system. Why I decided to focus on this, not other approaches to machine learning, and there are dozens of them. First reason, because this approach is recognized as being very useful to pattern matching, classification, prediction, and recommendation. And all this is important in respect to PPT and other tax rules, especially anti-tax avoidance rules. So how AI will learn here? So the process of learning will go through first stage, receiving answers to questions in different situation. And different situation is simply speaking different transaction or arrangement that you have knowledge about. So in time, more answers are provided. AI will be increasingly equipped with to undertake partly supervised recognition of treaty abuse by reading contracts. So it will be like transition to the second stage. And in the second stage, AI will be capable of uncovering new fact patterns. So first stage, there is algorithm, which will focus on the fact patterns that we can already determine by reading BEPS Action 6, by reading case law, by reading publications of top experts, and by using our knowledge. But in later stages, AI will be capable of uncovering new fact patterns that we will be aware of only once seeing them in the new case law in dispute with tax authorities. This will anticipate that. So eventually, it will be capable to evolve towards a completely unsupervised learning algorithm. And here I put the deep neural networks as an example, trained by a novel combination of supervised learning from the initial input of human experts with the use of classifier system. But it was this I included on 22nd March, and today, 1 hour before coming to you, I read an article of Professor McCarthy, the same professor who invented Taxman in 1972, but he was then assistant professor. Now he is professor emeritus of two domains, law and computer science. So he's an amazing guy. And according to him, deep neural networks are not suitable to address law, because we still don't know why deep neural networks works, but as lawyers we need to know why something works or not. And he proposes different approach, but it's all under the question, and what direction eventually we should take to develop the highest levels of AI in respect to PPT and other domains of tax law is to be discussed with AI experts. Now it's just the pure theoretical debate. So how to identify treaty abuse fact patterns? I will now share with you the path that I followed during the research in Singapore to discover the fact patterns. So first, applying a worldwide recognized interpretative approach. So I applied Article 31, 32 Vienna Convention, which is the interrelated linguistic, contextual, and purposive approaches. So language was easy, looking into the language of rules. Context, BEPS Action 6, commentary, cases regarding international tax avoidance, and authoritative publications. Purposive approach, looking into new preamble, new operative purpose, which is prevention of tax avoidance, and so on and so forth. Yes, new preamble is indicated here. So focusing on double non-taxation, double taxation. Tax treaties should not lead to such results. BEPS Action 6, commentary. This also meant to focus on interpretative sources that are common for every country, despite of their fiscal agendas. Why? Because Otherwise, we will have mess as we have now. Every country will have different approach and different views on application the PPT. So the algorithm that I will use tonight with you to test its precision, and you will tell me if you agree with the outcome, is purely international in its nature. Nothing precludes modification of that technology by country adjustment. For example, you can ask me, I am interested in that product, but I am Brazilian tax lawyer and I am not idealistic like you. I want to be efficient and effective in my tax advising to my client. So why not make small changes in your algorithm? I will provide you with knowledge regarding Brazilian tax authorities' approach and our case law, and make few changes so that we know that we have product that will increase the precision of identification of treaty abuse from Brazilian perspective. Nothing precludes this. But remember that PPT is not Brazilian. PPT is in the Brazilian tax treaties, and every Brazilian tax treaty has counterpart in the form of our country. So I would still defend the thesis that the most effective AI technology to PPT is the international algorithm, not country by country algorithm, but nothing precludes such tweaks. So eventually, I combine the outcomes of my qualitative legal analysis with quantitative statistical approach. And results of my qualitative legal analysis you can read in the World Tax Journal, the recent publication online from March in a paper in May 2018. It's the very big article about principal purposes test. Then you can find fact patterns that I use to design algorithms. Then you can find the whole reasoning that I used to come to that conclusion. Actually, this is so far my one of my biggest academic achievements, because publishing in World Tax Journal is very challenging, and I receive amazing feedback from anonymous reviewers, for which I am very grateful for them. So now we are approaching the pragmatic part, more empirical part of the presentation, but because you will see something very basic in the form of design, I want to still explain you a little more what is under this simple design. So crucial treaty abuse fact patterns are economic substance and non-tax business purpose. Why? Because you will see in my article in World Tax Journal, and not only my article, many other scholars and tax practitioners agree that although the PPT does not refer explicitly to economic substance and non-tax business purpose, it is quite clear if you read the PPT together with the wording of the commentary that economic substance and non-business purpose are very important for the proper application of the PPT. Moreover, substance over form doctrine has been recognized for many years. Also you. Imagine that you know that there is a company in Switzerland, and that company has 300 employees doing their job. Would it be, in your view, company with economic substance or not? Yes, everybody says, of course, yes. Why? You know nothing more, you just know that there is 300 employees. Yes, but the universe doesn't start any non-tax benefit. And now, why would you say yes? I urge you to restrict your knowledge to that facts. We really don't know what would be non-tax benefit. What we know here is that one company will increase by 1% its shareholding in another company. But look on the context. They exist for 5 years, which means that there is business established between them, which means that there is strong shareholding bound between them. Maybe by increasing by 1%, of course, there will be a tax benefit, but we don't know how big is it. There will be reduction of withholding tax, but we don't know if the dividends paid this year will be 1 billion or there will be very little dividend. We don't know that. So I would answer, I don't know.
Yeah, let me try to interrupt and also stimulate the audience to participate. It's not clear in the example, right? We could be talking about a 15% withholding tax as a general rule, and by increasing the participation to 25%, now the 15% is reduced to 10%. So when you say 80-90% of difference, in that case, you know, I'm receiving 33% benefit because the general rule is 15 and now I have 10, so it's just a 5% benefit. It's not significant.
Yeah, but to answer whether it's significant, we need to know what is non-tax benefit in terms of in different terms that the reduction of taxation. For example, maybe this 1% of shareholding means that these companies will continue business together, and if not, shareholders will escape the structure, will no longer credit the structure by equity because the tax cost paid on the dividends for them will be intolerable.
I understand. So if I have to pay $150,000 to buy this additional 1%, and by doing so I receive a benefit of $1 million.
Yeah.
So that's what I have to compare.
Yeah.
The non-tax benefit
but we don't
with the
know
tax
that.
benefit.
And this case is the OECD case, and whenever OECD, if you read BEPS Section 6, whenever OECD wants to emphasize that there is an element of the case which is important for treaty abuse, it is emphasized. But in that case, it's not. So I would answer, I don't know. To me, I don't know is more precise, more accurate answer in these facts than yes. You need to focus on the example explains this. You need to focus on the monetary outcome of the transaction. If the monetary outcome is 1 million tax savings, by comparison to 500,000 non-tax savings, it's not significant. Significant is only 80-90% more. We need to know monetary outcome. If we don't know monetary outcome, answer should be, I don't know. You should not guess.
And this could vary over time, right?
Yeah, you should not guess. We will have Brazilian cases thanks to the Victor's help, and then we can ask Victor if he knows a bit more, and then we can answer more precisely with the expert sitting on my right hand. But if you are not sure, you should not guess. This is a serious thing. This is the case of your client in international business. So you don't need to answer yes or no is not better than I don't know in every question in this algorithm in order to receive the appropriate conclusion. But the reason why I explained it to you here is that I want to have a full consensus with you what should be the answer. So I will not force other answer than yes if you think it's yes, but in my view it's I don't know.
Yeah.
Perhaps some other numbers, like what he pays with 24% and what he would pay with 25%.
Yeah, we would have to compare the price for acquiring the 1%, and also maybe there are benefits that come with the 1%, right? Because there are dividends attached to it.
Yes, as I said, let's imagine that you will provide a proof in front of the court according to which during the general assembly of shareholders, the decision was taken that if the if the returns from that investment will continue to be at this level, they will withdraw from the interest, and the taxation at the lower level, let's say not 30% but 5%, will significantly increase the return to the investors, and they will stay. So this is like the entire business. So then obviously answer will be no, because this 1% is much less important than non-tax benefit, which is the existence and the full scheme. But we don't know that.
Yeah.
And therefore the answer should be I don't know.
Let's go with I don't know.
So second question, is entering into this arrangement or transaction done essentially for treaty benefits? And essentially means similarly to significantly, almost 80-90% of the probability of the reason. Yes, right? This is written in the text that the transaction has been made primarily, which is even more or the same like we can say essentially. So answer is yes, right? Question number 3. Does this arrangement or transaction involve contrived, transitory, preordinate, or commercially unnecessary artificial steps for their realization?
Yeah,
Yes,
there's no-
exactly. This is a normal routine to increase by 1%. They don't try to overcomplicate by having loan, establishing new entity, issuing promissory notes, whatever. There is just genuine increase. So answer would be no. Is this arrangement or transaction done essentially on paper and or via electronic platforms without resulting changes in the physical world?
No.
No. I would say, well, how they did it, they only increased the shareholding, right? To increase shareholding is enough to write agreement regarding the increase of shareholding and transfer the money that you buy at 1%. So I would say yes. This arrangement was essentially done on paper or electronic platforms.
Let us take a look at the example then.
Example pertaining to the affirmative answer: assigning the rights to the payment of dividends or acquiring or of the usufruct of the preferred shares. Example pertaining to the negative answer: manufacturing and selling products, transportation, selling and buying services.
So it seems yes, right?
Yes.
Yeah.
I mean, example is only context. You don't need to follow the context. But I would say that the increase of the shareholding does not require the changes in the physical work. Only changes are on paper and via electronic devices. Are parties involved in this arrangement or transaction related to each other? Obviously, yes. They had 25% for 5 years. Does this arrangement or transaction entail circular cash flows? No. It would if the increase would be correlated with some obligation of the company
To
in which,
return the
yes,
amount,
yes,
to return the
like
amount.
promissory notes, but here is no. Has the jurisdiction chosen essentially because of tax advantages? No, because it exists 4 years before even existence of the treaty. So it was a pure business or investment reason.
So I'm sure we're going to talk about this later, but we haven't seen the results, but just a curiosity that we have. And we're answering lots of things yes. But
No as well, and I don't know.
no, but like the first one
Yeah.
are a lot of yes, but it's because it's a typical of the operation of buying shares. Like the parties have to be related, the parties.
Why?
Yeah, you're afraid with the yes answers, right?
Yeah.
The more yeses we give.
The reason why I chose this case is that this is increase of 20 from 24 to 25, and under PPT, obviously the principal purpose is to obtain treaty benefit. So this case was disputed. Some people said that it could be the benefit could be denied under PPT. Some don't. But what was interesting that both views, in my view, were not supported as they could be. With using algorithm, I found 2 additional arguments to protect taxpayer, but I will tell you in the end what they were. A fascinating thing was that without using algorithm, I would never go that far with looking for justification. So using math to our legal thinking, I think it's a future. But let's go to question number 8.
So that was a no, right? The jurisdiction was already there.
Is the jurisdiction chosen essentially because no?
And I learned from my friend here that yes is the bad thing.
Yeah. So it's no because it's not necessarily bad because each question has. This is a bit of secret, but I can tell you. Each question has different value, and each question in the juxtaposition with other answers also changing the value. So there are at least 3 layers of readjustments. So if you are typical lawyer or typical tax authority and you say answer yes here is like, come on George, treaty abuse.
Yeah.
But it's not like that, and life is not like that. So this is what that algorithm tries to reflect. So we say no, it's obvious that no, and 9. Would you say, and this is more sophisticated question, then this arrangement or transaction not contribute to or not have a potential to contribute to an economy of contracting states at large from a business or investment perspective, or do so only marginally? If you need help, you have example. But Yeah. So, what is your answer? Remember the context. They exist for 4 years. And year number 5, they will increase the shareholding. So there is, first of all, increase in the investment. And secondly, it is strengthening the bond between two contracting states. So I would say that no, this transaction will not. This transaction doesn't have potential to contribute only marginally or not contribute at all. This transaction has potential to contribute to the economy because the structure will exist for the next. Imagine, after 4 years, you decide to invest more in the other country. What does it indicate? That you will run away from the country next day or you will stay longer? Rather that you stay longer. But if you establish special purpose vehicle, SPV, only for one transaction, treaty benefit, then probably you will disappear. So the economy of that country does not benefit. Only your client benefit and you. So I would say no. Question number 10. Is the entity established and or used essentially for tax purposes? No, because they were 4 years before and we have 5 years. They still exist. Does the entity reliant on the personnel and management or of other companies established in countries other than the entity's resident state? No, we have nothing about that. Probably they are two separate companies, that just one controls another. Is the entity essentially engaged in passive business or investments? We don't know that. Maybe they are completely active. So I would say I don't know. And the last question, are entities involved in the arrangement or transaction newly established and liquidated soon after the arrangement or transaction were conducted? Typical SPV,
yeah.
no. So after that, we will see the result. The result is 21.01% likelihood of treaty abuse. The transaction undertaken by the user will not constitute treaty abuse under the PPT because the likelihood of treaty abuse is very low, 21.01%. Hence, the anticipated treaty benefit in the form of lower withholding taxation on dividends paid by ESCO to ERCO will be most likely retained, and then you have justification.
What would be considered a high likelihood of treaty abuse?
80% and more will be highly likely.
But I like the answer now. I was afraid
Yeah.
because I thought so many answers and it's not a treaty abuse. Like,
Yeah.
I don't think it's wrong for you to make the most of treaty benefits.
Yeah.
Yeah.
You
The-
just
the-
can't, what they are, you
Yeah.
cannot say my opinion is that you can't not pay tax everywhere.
Yeah.
The conclusion is that because when I was presenting that in Singapore, they answer it differently than you. The risk was even lower. It was 18%, but then one lawyer said 18% of risk and you are happy. I would cry because they still think like lawyers. You need to look. What does it
You
mean?
have to remove all the risk, yeah.
You need to look on 20% from the statistical significance, and 20% is significantly low, statistically speaking. That's it. So then they ask you what to do with residual risk, as if you don't have residual risk after a tax advice of PwC. You also have residual risk, with one exception. You don't know about that, or you are not aware how big it is. Here you know it's 20%. It's quite a lot. I would say. Why? Because of this on the specific case. But you have 18% that this is not treaty abuse. And you have justification why by analyzing answer to our questions. So, for example, what was important here? Okay, transaction was done essentially for treaty purposes or paper between related parties. So this question were are responsible for 20% of treaty abuse. But what is responsible for 80% of not treaty abuse are answers 2A, 2D, 2A, 2F, and 2G. They imply that the transaction was conducted in a typical and genuine way. It did not trigger circular flows of cash and have a potential to contribute to the economy of contracting states. This is something that I didn't know, that this is important when I think about advising to my client. Let's think what our transaction can do for the economy of the state, of the destination state. Nobody thinks about it. But if you think about it, and the answer will be yes, our transaction has potential to contribute to the economy of the treaty state, then this is very good for not treaty abuse. because this is the ultimate purpose of tax treaties, to contribute to the increase of international commerce, right?
Yeah.
Contracting states are not doing that, not concluding tax treaties because they are super happy to help every taxpayer who is engaged in international commerce.
And that's also something I have been commenting on, the principal purpose test. We as lawyers, when we apply the sole purpose test, which is normally the fact of the domestic law GARs, right, like the one we have in Brazil, we are used to denying for all purposes that there was an intention to have some treaty benefit. But the principal purpose test is different. You can say out loud that one of the principal purposes was to obtain treaty benefits. But that would not be a problem, because there are other clauses in the principal purpose test, and you can say that even though one of the reasons was to obtain treaty benefit, it's not reasonable to conclude that this would be a problem, especially because it might be aligned with the purpose of the treaty, right?
Exactly. And what is aligned with the purpose of the treaty is actually difficult to say, because every provision of the treaty has own purpose. Then you have operational purpose, elimination of double taxation, then you have prevention of tax avoidance, then you have ultimate purpose, and this is a mess. I think that in every case we need to look at this, it will be super time consuming. Answering these questions, if you are tax advisors, will take you 10-15 minutes. Of course you can disregard it, but if you do it 100 times, and out of 100 times, 99 times it's very in line with your intuition and conclusions of your senior advisors, I think it's something that should not be ignored. But this is the first question. I want to do with you 4, so let's do the second one. The second one, if you can read, is example case 2, example A, paragraph 187, commentary on the PPT. Hey, and by the way, I'm sorry, the conclusion of the algorithm is in line with the conclusion of OECD. In that case, it was example E, right? Yes. So the conclusion of OECD was, in that case, although one of the principal purposes for the transaction through which the additional shares are acquired is clearly to obtain the benefit of Article 10, Paragraph 2, letter A, Paragraph 9, which is PPT, would not apply because it may be established that granting that benefit in these circumstances would be in accordance with the object and purpose of Article 10. The subparagraph uses an arbitrary threshold of 25% for the purposes of determining which shareholders are entitled to the benefit of the lower rate of tax on dividends, and it is consistent with this approach to grant benefits. Okay, so the second case, are you all on this page? So I will read it aloud also. ERCO, a publicly traded company resident of state R, owns all of the shares of ESCO, a company resident of state S. TECO, a company resident of state T, which does not have a tax treaty with state S, would like to purchase a minority interest in ESCO, but believes that the domestic withholding tax on dividends levied by state S would make the investment uneconomic. ERCO proposes that ESCO instead issue to ERCO preferred shares paying a fixed return of 4% plus a contingent return of 20% of ESCO's net profits. The preferred shares mature in 20 years. TECO will enter into a separate contract with ERCO, pursuant to which it will pay to ERCO an amount equal to the issue price of the preferred shares and will receive from ERCO after 20 years the redemption price of the shares. During the 20 years, ERCO will pay to TECO an amount. Okay, let's try to answer to first question. Will entering into this transaction essentially result in a significant tax benefit as opposed to non-tax benefit? I would say yes, but we don't know enough facts, right? So again, I would take the approach to answer I don't know, but you decide what should I answer in that case. I don't know or yes, what would you rather answer? Yes? Okay. It doesn't matter because algorithm can change that answer to number 1, correct this. So, but I agree with you. It's rather yes. It's just It's blatantly artificial, but let's go further. Is entering into this arrangement or transaction done essentially for treaty benefits? Yeah, for sure.
Yes.
It's in the text. Does this arrangement involve contrived, transitory, preordinate, commercially unnecessary steps?
Yes.
Many, right? Like it's like nobody buying shares and saying normally in that way. Is this arrangement on transaction done essentially on paper? Yes. Are parties involved related? Yes. Does this arrangement entail circular cash flows? Yes. The only non-circular cash flow here is this difference. There's like fixed return 4%, 20 years, something you pay. It's almost entire circular cash flow actually. Has the jurisdiction chosen because of tax advantages? A company resident which does not have a tax treaty would like to purchase. No.
No, it's specifically circumventing that.
Is the jurisdiction chosen essentially because of tax treaty? Yes.
Yes.
Because they were looking for the treaty and they established that company. Would you say that this arrangement or transaction non-contribute to the economy or contribute marginally? Yeah. I would say yes. How they can contribute to economy by this transaction? 20-year, you sell, you buy, you require
It's a minority shareholding.
Yeah, it's like, and 20 years, 4%. I would say that, yes, they can contribute at most marginally or not at all. This means yes here, right? Yeah? And we have already result. You know why? Because algorithm works like that try to save tries to save computational power when it's obvious that they are more important reasons here, and I want to share with you. PPT, like you said that PPT is different than the sole purpose because it's reasonable to conclude one of the principal purposes, and this is quite easy to do, but it's not easy to say that something is contrary to the purpose of the provision. And what is also important, PPT focuses on arrangements and transactions. PPT says nothing about entities. Of course, you need entity to conclude the transaction or arrangement, but it's not that important as the transaction as such. So the algorithm focuses also on arrangements and transactions. And if that focus brings significantly high treaty abuse level, to not be overcomplicated, it's called overfitting. When you put too many data that is needed, in order to escape overfitting, algorithm eliminates certain answers and conclude. And this is the case. Why? The result is 91.3% likelihood of treaty abuse. So it's more than 90%.
But that's
that
the
is
highest
treaty
one
abuse.
can get.
No, the highest is 100%. Because we had like the yes, or two, I think. No, and I don't know. So the conclusion here is the anticipated treaty benefit in the form of lower withholding taxation on dividends paid by ESCO to ERCO will be almost surely denied under the PPT if applied by tax authorities. Even assuming that the answer to the main question one would be I don't know, which is not our case because we answered yes, and stays like that, which is unlikely because the match done in respect of the questions in the category 2 will readjust it to yes anyway. The likelihood of treaty abuse will be very high, 90.09. So even if you say I don't know to 1, the difference will be 0.3%. 0.3%. It's so low. So it's very high precision of this algorithm. But if you don't have algorithm, if you say I don't know if this is big treaty benefit, by contrary, I know this is big treaty benefit, look how it sounds, so powerful to have this knowledge. But for algorithm it's not important because it has other elements that are important for determining whether or not it is in line with the purpose of the treaty and so on and so forth. And there is the justification. So the product will be capable to advise you what to do. The last sentence says, consequently, it is advisable to abandon the idea to pursue these transactions and re-evaluate the expertise of tax advisors who recommended to pursue them. It is highly recommendable to chief tax officers and other senior managers insofar as they are subject to the rule of corporate social responsibility.
We evaluate the expertise of tax advisors who recommend.
Yeah. Yeah, you can speak with them if he knows what PPT is and why he still recommends you as CEO to do this risky transaction. If he says that it's ridiculous what the product says, it's up to you what to do with that knowledge. But this is for you, very quickly. So let's do now Brazilian cases. Let's do Brazilian cases. I anticipate challenges. Maybe you can read, Victor?
I will do that and just notice that case 4 is wrong here, so, but I have it on my phone. And
You can read from,
Yeah.
This is wrong case.
This is the right one, but the Mexico is repeated.
Okay,
the
great,
Austrian
no
again. But
problem.
I'll do the
So
Austrian
let's
then.
start with the right one.
Yeah.
And
So, BRCO is a Brazilian company that manufactures products in Brazil and sells them in Brazil and worldwide. BRCO owns already subsidiaries in many countries, which operate buy-sell activities, buying from Brazil and selling to the other countries, right? Without any additional production processes. BRCO decided to set up a AUCO, an Austrian holding company, to concentrate its investments in subsidiaries in Europe. AUCO has a small office in Vienna where it engages 2 part-time employees. AUCO performs financial support for the European subsidiaries, that is centralized cash management, and we can say that income produced by these financial activities are small when compared to equity revenue booked by AUCO. BRCO, the ultimate parent, right, benefits from dividend exemption provided in the Brazil-Austria double tax treaty.
okay, so I think that you wrote it in a very friendly way. But question to you: if I understood correctly the scheme, the BRCO benefits from dividend exemption provided by the Brazil-Austria tax treaty only because the company with 2 part-time employees was established in Austria, right?
Yes.
Okay. Whatever additional questions you will have to answer to the algorithm questions, Victor is ready to answer, unless you have probably in Brazil this like you cannot say too much about, of course, cases, but we don't know any names here, nothing. It's just Austria for AUCO and Brazil from BRCO, so I think we are all safe. But whatever.
Well, if this was were a court hearing, I could not say I don't know, right? I must say yes or no.
You can say I don't know.
All right.
Of course you can say I don't know, unless you are in North Korea or other country like that. But we are in Brazil. So first question, will entering into this arrangement result in a significant tax benefit as opposed to non-tax benefit?
Well, if we're comparing numbers, right, I would say that the profits from the subsidiaries that are now under this Austrian holding company is quite huge. And the fact that we are now saving taxes in Brazil because the Brazilian CFC rules are very bad, and Brazil has very few tax treaties that provide for the dividend exemption. So by having these particular these subsidiaries under the European holding company, the ultimate parent is having a significant tax benefit, because the non-tax benefit of the cash management is really low when compared to.
So that's great. That's something that we would not find normally in the OECD examples. And it's very important. I'm super grateful that you said this, because to all of you guys, you are welcome to contact with me either directly or via Victor, because I would look for many cases that I can test it. The more cases are tested, the better. Now I have no possibility to send to you password and login, because it's written only in JavaScript very quickly by my friend. But eventually we will put it on the server by using fully encrypted system, so that it will be impossible to see how algorithm looks. But it may take some weeks or months, because now I am in travel and short holiday. But if you have more cases like Victor, or if you have more cases, I would be very happy to use them. First, because they are real life cases. Secondly, because they come from you, from expert. And third, because we may have more details to answer these questions more precisely. I will use all cases provided by OECD, which is around 34. But problem with OECD cases is that there are only 4 or 5 cases of abuse and 30 cases of non-abuse. And machine learning does not like this disproportional cases. They like 50-50 or close to 50-50. Okay, so we answer yes to the first question. Second, if it's done essentially for treaty benefits.
Essentially, meaning 80-90%, right? So
Yeah,
I would say yes. It seems to me the question 1 and 2 are quite. Two is the question that corrects the answer to.
No, it's not enough to
No,
correct, for sure not.
So I would say
But they are of course very important.
there are other reasons, of course. We're benefiting from the fact that we now have this holding company, but the treaty benefits are
Essential.
significant.
Via Austria is fishing.
Okay, next one. If this transaction is artificial, contrived, commercially unnecessary, if the transaction includes steps that are contrived, transitory, preordinate, or commercially unnecessary.
No, it's a very straightforward.
Okay, so no. Is this arrangement done essentially on paper or via electronic platforms?
Of course not. We have an office in Vienna and two very handsome employees there.
What does it mean part-time? It's part-time.
Because no one works full-time in Europe.
Okay, but you are talking about structure. The question,
Except for you, of course.
the question is not about structure. The question is only about transaction. So here you have the transaction is to.
To set up the holding company.
Okay, I
Yeah,
understand.
but we did. We
So
did
answer
have
is
to
no.
change the physical word.
So answer is no.
It's without the result. No. Yeah, the answer is no.
Are parties involved in this arrangement on transaction related to each other?
Yes.
Does this arrangement entail circular cash flows?
No, certainly not.
Has the jurisdiction chosen because of tax advantages?
Yes, there are very few treaties.
Thank you. I thought that Victor will stick to no.
No.
But we have the. And next question, is the jurisdiction chosen essentially because of the treaty?
Yes.
Obviously, only treaty with
Yeah.
Brazil with exemption of dividends.
No, it's easy. If you want to search for the treaty, the Brazilian treaties that provide the dividend exemption, those are the countries which first letter is a vowel. So Argentina, Austria, India, Argentina maybe no longer. In the
Okay, next question. Would you say that this arrangement contributes only marginally to the economy of Austria in that case?
Yeah, just these two part-time employees in the office. That's just a marginal.
So I think it's marginal, right?
It's marginal, yeah.
Yeah. Okay. Is the entity established?
There's no additional investment, especially, right? Because the
Mhm.
subsidiaries have been there already.
Yes, I
It's just
understand that. But, is the entity established and or used essentially for tax purposes?
Yes.
Yes, but this yes was not that strong.
Yeah, because every question has this word, like essentially, substantially. So when you read it, yeah.
Sure, of course. There are always two examples for answer yes and no in order to yeah. So the example here, example pertaining to the positive answer, establishing intermediary company, conduit company in a jurisdiction that has network of favorable tax treaties and low or non-taxation of passive income solely to benefit from low or non-taxation under these treaties and the preferable tax law of that jurisdiction. The role of that company is essentially restricted to receiving and paying passive income, exempli gratia, dividends, royalties, interest, capital gains, which are not connected with the company's business activities from two non-residents.
It's a very strict test.
This is what I try to add to PPT. And it's not meant to be immune to criticism of whatsoever. By contrast, I welcome criticism. I want to make it better, right? Example pertaining to negative answers, establishing manufacturer or regional headquarter for management purposes.
Oh, it's a regional headquarter for management purposes then.
It is?
Yes.
Yeah.
Yeah, but the answer was yes, so...
Yeah, we'll go for yes.
But
yes is...
I mean, therefore, this is that word essentially. If you don't have this word, you would still balance and argue like lawyers do. And there is explanation of essentially in the form of the percentage, which means 80-90% of the reason. So you have this 10% margin, which is the regional headquarter. But if not tax treaty with Austria, if not treaty benefits, if not all those things, would you do that? No. Why? You could do it everywhere, right? But this is only one particular question, and this question does not make you in trouble, put you in troubles or not?
Yeah, I would change my answer.
No?
I would say that we needed these
Okay.
centralized.
So let's say no. I knew
headquarter.
that Brazilian cases will trigger troubles.
And you can see from the facts that if we wanted to only have treaty benefits, we would put all subsidiaries in the world under this holding company, and we only did that with the European subsidiaries.
Yes, but you did it because Brazilian CAC rules otherwise will tax their income on the current basis.
But we still have other subsidiaries like in Asia or in the United States, which we did not use.
Okay, so I will phrase this question again. The entity in Austria, essentially speaking, is not established for purpose of circumvention of Brazilian CFC rules.
Not only for that.
I'm not saying only, I'm saying essentially.
Essentially.
80% of probability.
Yeah.
Yes? Because if yes, answer is yes.
Well, let's go for the yes then.
PPT has three roles. First, to combat treaty shopping. Second, combat rule shopping. And third, combat the circumvention of domestic anti-avoidance rules, for example, CFC rules, blah, blah. So I would say yes.
Yeah, let's go for the yes.
Yes? I mean, let's
So
say...
you know, that was the trick. That was why I only put European subsidiaries.
Yes,
under
I
it.
know.
Yeah.
I know that.
Yeah.
Let's say that you are the president of the court and they are all our judges. So if there is a majority, we cannot overrule their judgment.
I'm not convincing them, so let's go for
But
the
I think the audience said yes too.
11.
11. Does the entity rely on the personnel and management of other companies established in countries other than Austria? So we know that you have 2 Austrian part-time beautiful employees. But the question, if the activity of that company is reliant on other employees, that these 2 part-time or not?
They do. They are not we also need the parent company support
from other countries.
For many, yeah.
So answer is yes. Is the entity essentially engaged in passive business or investment?
Yes.
If you don't know, then you have example, of course. And last question, are entities involved in the arrangement or transaction newly established and liquidated soon after arrangement? No. Yeah. But I would say that I should change this question and say and/or, because this entity is newly established.
Oh, yeah.
Right? But so I think that question is slightly imprecise. But I need to answer no because the question is a little bit not perfect. Result, 73.91% of treaty abuse. So it's significant. It's not highly, but it's treaty abuse, I would say.
Employees were not part-time.
Doesn't matter because what is important is that they could be part-time if this part-time employment will be enough to cover 100% of the activity of Austrian company. If this part-time employment covers 1% of the activity, while 99% of activity is
done somewhere else.
Yes, is done outside the country of residence. This is one of the most important factors for conduit companies.
And when you said about the holding company, if they put the Austrian company as a holding company to manage all the European subsidiaries.
Yeah, and if it's self-sufficient, right? If it
Yes,
works,
so precisely.
Instead of just having this and to have employees, you could have a director.
Exactly, and they need to thank you, and they need to how to say this beautiful word, they need to prove that they have enough qualifications, let's say MBA from London, experience from other companies, and boom, you make them the main senior officers for the entire European group. Last case, Brazilian again.
I'll have to read it from here.
Okay,
'cause
sure.
Yeah, what you have there is the Austrian case again. So it's pretty simple, but also a little more complicated than the other one because it involves potential benefits in more than one country. So HK Co. is a Hong Kongese company that acts as the headquarter of a large multinational group that manufactures electronic products. So you have this Hong Kong company as the ultimate parent. HKCO decided to open a sales office in Brazil to perform buy-sell activities in the Latin American market. So they want to set up a subsidiary in Brazil. The initial plan was to fund BRCO mainly through debt, mainly through loans. However, as Hong Kong is a blacklisted jurisdiction in Brazil, the withholding tax on interest is quite high, 25%. In order to avoid this burden, HKCO chooses to set up BRCO as a wholly owned subsidiary of Mexico, an already existing subsidiary of HKCO who performs substantial manufacturing activity in Mexico. So Hong Kong decides to put the Brazilian subsidiary under Mexico instead of putting it directly under Hong Kong. Pretty normal decision of investment, right? You already have a factory in Mexico, it works, it has many employees. And so what happens after that? Mexico receives 1.5 million US dollars from headquarters as a loan. So a loan from Hong Kong to Mexico, and set up the Brazilian company because of that equity thresholds, right? The 1.5 million then become 500,000 US dollars of capital in Brazil and $1 million as loan. In doing so, the flow of interest from BRCO to Mexico is now subject to a 15% withholding tax, and in view of the Mexico-Hong Kong double tax treaty, and this is reality, the flow of interest from Mexico to Hong Kong is subject to a 10% withholding tax.
Great. So first question again, is it a significant tax benefit in comparison to non-tax benefit? So what non-tax benefit follows from that? Is there any significant non-tax benefit?
Well, Brazil is a new market to us, so we are going to benefit a lot from setting up a subsidiary in Brazil. But you're asking Mexico, right? By using Mexico. Well, there's not really nothing else because we already had the factory there. There's
so the reason why to route the transaction via Mexico is significant tax benefit.
Yeah, just a.
Sorry, perhaps I didn't get, but aren't you paying 25 either way? Because Hong Kong, Brazil, Hong Kong, you pay 25 because it's a tax waiver, but you also have issues with it that you pay doing.
No, but Hong Kong didn't send the loan to. Yeah.
Hong Kong sent to Brazil, you pay 25, and you also have those additional.
I see. I understand. That's a very good question. There's a 15% withholding tax in one country and a 10% withholding tax in the other country, which I'll have to find cash to pay that, right? But anyway, that's a very good question. The Mexican company has a large taxable profit. So the 15% of Brazil, we will use that as credit in Mexico. So that's already in our pockets. So it's just the 10%. The 15% will really cause no.
So it's
cash
15%.
problem.
If there was foreign tax credit and if there's an offset.
Exactly.
Yeah.
So in an overall perspective, we're
Yeah.
paying only the 10%.
So the entire picture shows that there is 15% tax benefit in
Exactly.
respect of the loan.
Exactly.
The next one, if the transaction is done
That's
for
a good detail. Thank you for bringing that.
whether this is done for tax treaty purposes.
Yes.
Hong Kong, Mexico, Brazil, Mexico. Does this arrangement contrive to transitory preordinate commercially unnecessary steps?
That's the question I wanted to discuss. Yes. Do you think so?
Yeah, because if you want the loan between two entities, you do the loan, you does it between two of them.
But isn't that a commercial decision? I have many people in my family,
Of
and
course.
I decide that
But the
particular person should be.
Yeah, but the
the one-
execution of the decision is slightly atypical. Yeah. And the next one is this. I want to go fast because it's already after 9, guys.
Yeah.
Is this arrangement done essentially on paper, electronic platforms? Yes, because you attribute loan to
Just,
entity. So you say Mexico. Are they related? Yes.
Yes.
Is the circular cash flow? No. No.
No.
Jurisdiction was chosen because of tax advantages?
Yes.
Because of the treaty?
Because of the treaty.
Yeah. contribute to the economy of Mexico?
No, we're doing that already. So, well, there's additional investment which was flowing already. Screwed.
It's already done
Already.
because the likelihood is significantly high, 80%,43. So this scheme, in comparison to the Austrian, according to algorithm, is not much more, but 6% more risky.
What is the concept? I don't think I got that. Circular cash flow.
The concept of circular cash flow.
Something in my mind in the beginning, but
Yeah, sure. So I will go back because every question has two examples of answers for the positive and negative. I will just quickly go to the circular cash flow. It's here? No. Yeah, okay, here. So before I provide you examples, circular cash flow is situation when you can draw the cycle for the flow of your cash. Does it make sense for you? So if you are here and you are seller S and you are selling something for 10.
Oh, take another one. Take the other one.
Yeah, it's
because that's what I have in mind. But here you just don't compete to Brazil because it's Hong Kong, Mexico, Brazil, and then Brazil, Mexico, Hong Kong.
no, but we don't have circular cash flow. Okay, once again, let's say this is Hong Kong. This is Hong Kong. And this is Mexico. And this is Brazil, right? So the loan goes like that. A loan to Brazilian company goes through the Mexico. Yes, doesn't close. Because if Brazil, under promissory note or other arrangement, would be obliged to pay everything what receives plus interest, like in the OECD scheme with a... So circular, you are capable of
Yeah,
making
a circular cash flow would be. Let me try to make it very simple, and you confirm if I'm wrong or not. If I make a loan, I would have to pay taxes, but instead of making a loan, I donate money to you, and you have the obligation to return money to me, right? So the money will come back.
Yeah, correct. But the ways how to do it are many. It's not only one way. It's just an example.
Yeah.
So with that, I would like to thank you very much for your precious time, and it was very great to share this with you. It was first time that I tested 4 cases. Before it was only 1 case, and Singaporean audience is much less active than you, so it was really great pleasure.
Yeah, well,
Thank you, Victor.
When I met Boje in Singapore 5 months ago, this was just an idea, and I'm proud to see this working, and I'm very grateful for you coming back to our country. We hope to see you again here many times, as you are a great friend of IBDT already. Thank you very much.
Thank you.